Is going to cover several aspects of legal and ethical principles. Some of our objectives are going to be discussing the responsibilities with respect to scope of practice, standards of care, medical direction. Also to talk about some federal state laws that affect your practice as an EMS provider, some different legal situations, tort, criminal laws, criminal issues, Good Samaritan laws, negligence claims, several different ways to defend yourself against claims of negligence, factors that can determine a patient's decision-making capacity or capability, as well as some situations in which you may be considered to be a mandatory reporter, assault, battery, abandonment, false imprisonment, and defamation. Differentiate when you can and cannot legally share a patient's protected health information. Discuss the EMTALA and HIPAA legislation and how it affects your practice as an EMS provider. Identify situations in which law enforcement or the medical examiner's office should be notified, and different legal considerations in response to crime scenes. Now, ethics are typically something that is agreed upon as right or correct by a collective group, such as people. All right? Your morals are more of a personal value that guides your individual's behavior. One example that I use that kind of highlights the difference here would be from an ethics standpoint, typically consensual sex is considered as okay. But morally, some folks believe that having sex before you were married is not good, and while others are fine with having sex before they are married as long as it's all between consenting adults. So it just kind of highlights the difference there between ethics or the collective group. Morals are more personal values that guide an individual's behavior. Now, the EMT oath and EMT code of conduct both describe expected conduct of EMS providers, and those are both linked in the modules. One of the biggest principles in your ethics is going to be primum non nocere. And what this means is, first, do no harm. This is really, really important, and this is kind of the cornerstone of all medical fields. Our goal is to help, but first we do no harm. We don't want to do anything that's going to cause harm to the patient. Now, the rest of our ethical principles here. Beneficence, which is going to be doing something good. Non-malfeasance, which means doing no harm. That's the primum non nocere. Justice. Right, concern for the well-being of others. If you don't give two craps about the well-being of others, this probably is not the field for you. Having respect for others is vital. People can tell if you don't respect them. Whether they've earned it or not, we should show everybody the same basic respect that we would show any other person. Being an advocate, this is super important because in a lot of situations we may be the only person that can advocate for what this patient needs, because the nurses and the doctors, they don't go into the patient's home most of the time and see what their living situation is or what's going on with that patient. So oftentimes we are the only ones that can get that information across. Patient's right to self-determination. I once had a doctor tell me the patient has a right to be stupid. And that always just kind of stuck with me, because you would think that most people make good decisions, and most of the time they want to do what's best for them or what we think is best for them. But sometimes patients just don't want to. And if they are in their right mind, we can't make them. We want to be objective. In this one, a lot of people think they are objective until they're put in a situation which they can't be. And so no matter how you feel about the person or how they got in the current situation that they are in, you need to be objective and treat every person with the same dignity and respect that you would want. We want to avoid any conflicts of interest. For me, as an instructor, that would be something like, I'm going to write a book and now I'm going to make all of you buy this book because that would directly benefit me. All right? Full disclosure. You need to be giving full disclosure. You need to make sure that your patient understands everything. If you are assigned to an ambulance unit that's attached to a hospital and taking them to that hospital, they need to be aware that it's owned by the hospital. Right? We have a duty for due diligence, meaning we're going to do our job and we're going to do it well, and we're going to do everything that we need to do or are supposed to do. We're going to maintain confidentiality. We wouldn't want all of our private business spread about there for everybody to see, so we don't do it for our patients. We have the great responsibility of going into somebody's home or lives, and usually in their worst time, and have just a few moments to get into their deepest, darkest secrets sometimes, and things that they may not even share with their family or friends, and we've got to be able to get them to trust us to tell us this stuff so that we can accurately treat them. That takes a lot. And then, of course, we have to adhere to our professional responsibilities, which kind of include all of these other things that we've already talked about. But doing no harm, making sure that we are patient advocates, and making sure that we maintain this confidentiality and perform to the best of our abilities within our scope of practice. There are several different areas of law that are going to affect how we proceed and how we do our jobs. Some laws will vary based on where you are based out of. So when we are talking about National Registry or just general, we're talking about not individual state laws necessarily, but just global laws and some examples of some laws you may see locally. So administrative law are going to cover things like your requirements to practice, which vary by state, but usually include something like a valid driver's license for that state, a current national and or state licensure, as well as having passing a drug test, having a clean motor vehicle record, some things like that. Right? Continuing education, or Con Ed, that's another thing that is mandated by National Registry, and most states kind of fall in line with that, but some do have their own, either it be less or more. But continuing education, EMS changes, medical field changes a lot, and it changes fairly rapidly. So the continuing education is designed to make sure that you are getting the most up-to-date information as things may change, such as suctioning of newborns or tourniquet use. Those are two things that big things have changed over the past several years. Licensure. This is what's going to determine who can or cannot get your licensure. Just because you completed a course does not mean you're eligible to practice that field. You have to go through the steps to ensure that you obtain your licensure and then are able to practice. Scope of practice varies, once again, nationally and state by state, although it is coming more in alignment with the national scope, but it details out by level everything that you can and can't do. For instance, as advanced EMT, you will be able to start IVs, you will be able to do supraglottic airways, you'll be able to give quite a few medications. So there are some more things that you get that you could not do at the EMT level, but there are still other things you cannot do that paramedics can do, such as intubation or cardioversion, things like that. And then you've got your rules and regulations. These usually are more local, but it may be things such as you can run emergency, but you have to notify the police department before you can run emergency through a town. Or regulations that say you must clean your truck or check your truck off every 12 hours or 24 hours. You must notify at least 2 hours prior to the start of your shift if you're going to be absent, things like that. For criminal law, these are things that are dealing with crimes that are against either society, which is in general, or against a specific person. Some of the ones that are concerned with EMS are going to be assault, battery, reckless driving, false imprisonment, and manslaughter. So assault is an act that places a person in fear from physical harm or impending physical harm. It's very important to note fear. You don't actually have to harm somebody. If you tell somebody, if you don't quit moving, I'm going to stick you with a big needle, that could theoretically be considered assault in certain circumstances. Now, battery is actually touching a person without permission. So we tend to think of this as in a violent context, like is causing harm to the person, but in fact, just unauthorized touching of a person is considered to be battery. So if you grab a person by their arm to help them to stretcher and they don't want you to, that could be considered battery. Reckless driving, the definitions vary by state, but usually include some aspect of excessive speed or maneuvering with lack of due regard. False imprisonment is another one of importance to EMS, and this is where there is a deliberate detainment of an individual without their consent when you don't have a valid reason, and that's important. That last part's important, when you don't have a valid reason. So if you are covering yourself with legal restraints and you have used them appropriately, reasonable prevention of harm, if the patient's suicidal or homicidal, and it's not in a punitive manner, then that's kind of a protection from this false imprisonment there. Manslaughter. Now, then we don't think about this one a lot with EMS, but if you are involved in a wreck that directly is the cause of another person's death, whether you're driving, if you're involved in that wreck, you could potentially look at a charge of manslaughter. And manslaughter is directly causing, specifically vehicular manslaughter, is directly causing the death of another person without intent. So this takes out that intent part. That would be up to murder, but without intent, manslaughter. In Alabama, that's up to 5 years, and I believe a fine of $2,000 or $2,500, maybe $5,000. It was 5 years and a lot of money. It's also important to note that if you give a person incorrect medication, not only could you be looking at civil problems, negligence, but you could also be looking at criminal legal issues as well if you directly caused the death or demise of that person. Now, as far as civil matters, family court, legal issues with that is going to be handled with tort. Some other issues we want to look at are slander, which is a spoken false or injurious statement, and libel, which is written false or injurious information. Both of these fall under defamation. And always remember this is S is for speaking, so you're speaking the slander. Now, with negligence, we have 4 elements that are needed to establish negligence. Right? There has to be a duty to act. All right, and this is looking at your standard of care and making sure that you are on duty. You have the responsibility to respond to calls and provide care within your scope of practice. Okay, you must obey all applicable laws, but this is saying that you have the duty to act. The next one is a breach of that duty. You had the duty to act, but now there's a breach. So you have deviated from accepted standard of care, or through doing something or not doing something. Maybe the standard of care, say for extreme nausea vomiting, would be to start an IV and give fluids, but you don't for whatever reason. Okay, if you give an unnecessary medication, if you do something that violates your standard of care, then it could be considered a breach of that duty. Now, they break the breach of duty down to 3 parts. You've got malfeasance, which is performance of an improper act. Misfeasance, an improper performance of a legitimate act, such as you started an IV but you did not notice that the IV failed. And then non-feasance, which is where you did not perform an act that should have been performed, such as you didn't start an IV on a patient because they told you they had HIV. You have to have a duty to act, breach of duty, and then next you have to have actual damages, which means there has to be some sort of problem. Okay, there has to be harm. All right, it could be physical, it could be psychological, or financial damages, all as a result of the action. And then proximate cause. What you did directly caused, or the lack of what you did directly caused the outcome. Now, it's also important to note, if you are found to have acted with gross negligence, which is, a wanton disregard for the welfare of the patient, then they may also seek punitive damages as well as actual damages. When we're dealing with civil cases, the defendant doesn't have to be proven guilty beyond a reasonable doubt like they do with the criminal court. The burden of proof is on the plaintiff to prove that an act of negligence was present. If the plaintiff invokes doctrine of res ipsa loquitur, then the burden of proof shifts to the defendant, which means the thing speaks for itself. So that's basically saying it's so obvious that the damages will not have occurred except for the defendant's actions. And there's no way that the plaintiff could have contributed to those damages. Now, some of these high-risk situations, which the civil law stuff comes into play. Medication errors. Medication errors are huge. There are way too many medication errors, both in what drug to give, how much to give, how to give it, how often to give it, did we give it to the right patient? So these are all things that need to be triple checked to make sure that we are not killing our patients. Right? Dropping or improper handling of patients. Some patients are very fragile, some aren't, but either way, we need to make sure that we are handling them in as gentle as possible, but in an appropriate manner that's not going to cause any further harm to that patient. Right? Emergency vehicle collisions. MVAs happen a lot, and they often happen when you have a patient in the vehicle with you. It's not worth it. Slow down, clear your red lights, drive with due regard, drive like it's your mother or your father or whoever you love best in this world in the back of that ambulance. The extra time that you may save, the minute or two that you may save by blowing through red lights or stop signs, one day is going to catch up with you. Now, as far as physical restraints, if we're going to use physical restraints, we need to make sure that we are legally able to do so. So we have to have a reasonable expectation that's going to prevent harm, whether that's because they are homicidal or suicidal. And we have to also make sure that we have the proper clearance and authority to do so, and that we're doing it in a non-punitive way that will not cause any further harm to those patients. Moving on to the next area is going to be consent. And consent can get kind of tricky sometimes because there's several different types of consent. A good overall protocol is going to be all patient care requires consent. We need to get informed consent from a competent adult patient before we provide care. All right. Also worth noting, competent adults have the right to refuse all or any portion of the emergency care. For example, they may want you to take them to the hospital, but if they don't want you to start an IV and they're competent, they have the right to do so. They can say, I don't want you to do an IV, and you cannot do one. Now, our types of consent we're concerned with: expressed consent, informed, minor, and implied. For expressed consent, expressed is exactly what it says, expressed. In some form, whether it be verbal or nonverbal, they are saying, yes, okay, I want this to happen. So for verbal would be, hey, Miss Betty, would you like to go to the hospital today? And she says, yes. Or nonverbal, Miss Betty, would you like to go to the hospital today? And she goes and sits on your stretcher. Most people are not going to go sit on your stretcher if they don't want to go for a ride on it. Informed consent is for making sure that they understand all the potential ramifications for what's going on. For instance, I had a juvenile one time who had a dislocated shoulder from a dirt bike accident, and we were going to a hospital. It was not the nearest hospital, but it was the most appropriate for that particular injury for that child. It was not a children's hospital. So one of the things I made sure to tell the mom was that I felt that, why I felt this hospital was the most appropriate for this particular situation. I also, before I called in and got permission to give morphine to this child, I wanted to talk to the mom and made sure that she understood why I wanted to give him the medication, what I planned that it would do for him, why I wanted to give it to him, how much I was going to be given, and the potential or what could happen, such as respiratory depression, and my plan if that were to happen, i.e. Narcan and or oxygen BVM. So I made sure that she understood everything. She had all the information she needed to make a good judgment call for her on whether she felt comfortable with me giving him this medication. In the end, she did. I called the doctor, I got permission, gave him medication, and all was well. But I made sure she had everything she needed to make that decision. Now, another type of consent is called minor's consent. There's a couple of things here that are of importance. So, with a minor, typically, if a parent or guardian is there, then they can give us permission. Right? If there is not a parent or guardian available, we're going to operate under an emergency doctrine minor consent, saying that we assume that it's reasonable to assume that a parent wants you to provide all reasonable necessary medical care to take care of that child. If they were there, they would give you permission. Okay. Now, second part of minor consent is dealing with emancipation. And emancipation means that they have been deemed legally an adult by several different ways. So the first and foremost is a court order. If a court says that you are an adult, they can be treated as an adult as far as refusal, consent, things of that nature. If they are enlisted in the armed services, so I believe you can enlist at 17. So if they're 17 enlisted in the military, they are considered to be a legal adult and can make their own decisions or refuse treatment. If they are deemed independent by other means, such as marriage or pregnancy or having delivered a child, then they are also considered to be emancipated by the court systems and legally for making their own decisions. And some states have additional guidelines. In Alabama, for example, at the age of 14, a child can consent to medical care, but they cannot refuse until they reach the age of adulthood, which is 19 in the state. So every state varies a little bit by some extra things in there. So it's always important to make sure that you check your local guidelines and rules and regulations for what is and is not acceptable. And the last form of consent we want to talk about is going to be implied consent. Now, this covers both minors and adults, but an implied consent states that it's reasonable to assume that any adult or any person who is unconscious would want you to provide them with the appropriate level of care. Now, they may wake up and tell you to stop, and that's fine, but until they do, we're going to assume reasonably that most people would want you to render care to them and give them aid. There's a lot of liability with consent, both in refusing and giving consent. Okay, so always follow your protocols and procedures. Contact law enforcement if necessary to enforce the consent. Involve medical direction and supervision. So don't make the decision on your own. Medical directors have a whole lot more insurance and a whole lot more knowledge and background than we do. So don't be afraid to use them and ask them and get some guidance here. Always act in your patient's best interest. Remember that whole patient advocacy thing. We want to make sure that we are trying to do the best for them. And document. Some of the biggest problems we see are from bad documentation. So make sure that we are covering this information. As far as refusal of care or transport, the patient must be alert, must be oriented to the person, place, and time. Competency. Only a court and a judge can legally determine legal competence, but medical personnel, we can make this decision or determine their decision-making capacity in an emergency situation, such as mental illness, behavioral, medical emergencies, intoxication, or trauma like a head injury that may alter their mental status. It's very important that you include law enforcement and or medical direction in these decisions to help protect yourself when making these decisions. For refusal of care, this is one of the highest risk areas that you will encounter in EMS along with your actual ambulance operations. Refusal must be informed. It has to be informed, meaning they must understand the risk of refusing care, such as death, dismemberment, alterations of life, things like that. They must be alert and they must be oriented to person, place, and time. I recommend that you document patient responded appropriately when asked for their name. Patient was able to provide home address. Make sure that you're giving that information because you're painting a picture if this were ever to go to court. You also must inform them that if the problems return or persist, they should call back EMS or see a physician. All right? And then document that they are refusing against medical advice. Okay? And then document. Now, some other things we want to look at here. Abandonment. This is where we have failed to make arrangements for continuity of patient care. This care must be equal or higher level of care. A claim of abandonment could occur in such a situation in which you initiate advanced life support care, such as starting an IV, and then you turn over that care to an EMT who does not have the ability to maintain that IV. Or if you leave a patient at a hospital and don't provide for transfer of care, you leave them in the hallway on a bed and don't get signatures and give a report to a nurse. Even if you stop at scene, potentially off duty, and then leave before other EMS providers arrive. So a lot of different situations which abandonment could come up. Really important to make sure that we always arrange for continuity of patient care, and it must be that equal or higher level of. With our Good Samaritan laws, now they do vary based on where you are, so it's always important, like everything else, to make sure what your particular state laws are, or if you're traveling, what the laws are where you are going. But typically, as long as you are exercising due diligence in all of your activities, as long as you are acting in good faith, you're not getting compensated, and that you are not acting grossly negligent, then you are immune from any kind of civil claims, such as, let's say you stop on the side of the road, there's a car that just had a wreck and it's on fire, and you were able to reach in and grab the driver and remove them from the vehicle and drag them away from the wreck. And during the process of this, let's say they had a spinal injury and then they were paralyzed after this wreck. They might try to sue you, but in most areas, Good Samaritan laws are going to prevent them because they probably would have died if you had not gotten them out. Your mandatory reporting varies by law depending on where you are, but typically EMS and first responders, volunteer and paid, are included as mandatory reporters. It also can include your DHR staff and things like that. As far as who to report, that's one thing I've always heard asked, who are we supposed to report this to? Typically DHR, or Department of Human Resources, the hospital staff at the ER, and or law enforcement could all meet those requirements of reporting the activity to. In Alabama, you have 24 hours to submit a written report if you are the end caregiver. So for EMS, by reporting our suspicions or problems to the staff at the ER or to law enforcement, can meet our requirements. Now, some things that may be included in mandatory reporting: child abuse or suspected child abuse, domestic abuse, sexual abuse, elder abuse, or neglect of any age or any way. For EMTALA and HIPAA, the Emergency Medical Treatment and Labor Act is a federal law that says anybody coming who presents to an emergency department has the right to be stabilized and treated regardless of whether they have insurance or they can pay. This also covers for the labor portion of it, is that if you present in labor, then you and the newborn will be stabilized and treated regardless of your ability to pay. Now, the Healthcare Insurance Portability and Accountability Act, or more commonly known as HIPAA, is supposed to provide data privacy and have some security provisions for safeguarding your medical information. So some things that specifically HIPAA provides for are making sure that you have access to your medical records, but also make sure that they're not shared with anybody who doesn't need to know. There are several situations in which you can access or share this protected health information. If the patient consents in writing, then you may share that information with whoever that consent says, such as a family member or something like that. Medical providers that need to know. So if you're turning over care to the nurse, they need to know what medical history or information you have for this patient. If the court orders this information turned over. If you have billing purposes, you have to have certain codes in order to get paid for the services you provide. So those codes are dictated usually by diagnoses. The patient can look at their medical records, request amendments, and find out who all this information was disclosed to. And then we can also share information with law enforcement in pursuit of their duties. You're having a drink with your buddy who's a cop at the bar after work, and they say, "Hey man, what happened with this call?" You can't tell them. If you are at work and law enforcement comes up in the back of the ambulance and needs to get the patient's name and date of birth for their report, you may share that information. So it just depends on the situation, but it has to be in pursuit of their duties. For crime scene response, there's a couple of key things here. First and foremost is protect yourself. Care for your patient and try not to destroy any evidence. Disturb as little as possible, touch as little as possible, and leave nothing behind. Make sure you're taking the same pathway in and out of a scene. You're not stepping in any blood or other bodily contaminants or anything of that nature if at all possible. Use the minimum number of providers. If you don't need 10 people, don't take 10 people in. If you only need you, only take you in, because the more people that are there, the more contamination that scene can receive. If you must remove anything from the scene, notify law enforcement. Make sure they understand and know what you're doing. Avoid cutting through any holes in the clothing that's from a gunshot or stab wound or anything like that, because that's potential evidence. And then document your observations and your actions. And anything that was used with the patient or on the patient needs to stay with the patient or on the patient. So any blankets, sheets, anything like that needs to be transported and left with the patient. Now, there are some legal protections that kind of help you along the way, because there's a lot here. But understanding and sticking with the standard of care, making sure that you're providing the standard care for each patient, helps a tremendous amount in protecting you. Exercising due diligence in all activities. Right? Acting in good faith, making sure that what you're doing is what you're supposed to be doing. Being professional in your appearance and actions. The Good Samaritan laws, there is a thing called government immunity. Right? It's really kind of limited, but what this does is say that in certain circumstances, if you work for the government, you may be immune to prosecution or through civil, but this is not designed to give individual protection. This is more of a company protection. Right, statute of limitations. This dictates how long legal action can be pursued, and after a certain specified time, no legal actions can be pursued any further. Right, statute of limitations varies based from state to state. It just depends on where you are. And then document. Make sure to complete all documentation as soon as the call is over to ensure that you have the accurate You want to make sure that you write your report to support your decision making. Make sure to include all relevant details. It's important to realize that most of the time when you are looking at a lawsuit or going to court or something of that nature, it's not going to happen 2 weeks after the call. It's going to happen a year, 2 years, even longer after the call, in which you've had most likely several hundred, if not thousand, patients in between there. So they start to blend together. So it's important that your PCR protects you. It needs to paint a picture for anybody to see who's reading it what happened during that call. If you don't document it, it didn't happen. Okay? So write that report to support your decision making, why you did things. Include your relevant details. Right? It should give a picture of how they presented so there's no question as to what the correct course of action was. Okay? If you did not record findings and procedures, you can't prove that you found all the relevant information and provided the necessary treatments. Make sure to present your information objectively. Right? Do not make value judgments or assumptions. Don't document the patient was drunk. Instead, document the patient stated he drank 7 margaritas between 7 p.m. and 9 p.m. His speech was slurred, his gait was unsteady, and there was an odor of alcohol on his breath. Let them draw conclusions from the facts. Write neatly and accurately, using proper grammar, sentence structure, terminology, and abbreviations. If you sound like an idiot in your PCR, they're going to assume that you are in fact an idiot. All right? Your documentation is a direct reflection of you and your professionalism. If you need to make corrections, make them promptly in an acceptable manner. Now on a computer, that's fine, you just backspace. But on written, you never scribble out, obliterate, or otherwise do anything to it. You draw one single line, and then date and initial the correction. If necessary, apply supplemental documentation to identify it as an addendum or amendment if necessary.